Please rise. The Minnesota Court of Appeals is now in session. Judge Schellhas, Judge Halbrooks, Judge Smith, the Honorable Heidi Schellhas presiding.
Thank you. Welcome to the Court of Appeals. Please be seated. The first case on the calendar this morning is the case of Sandra Sue Grazzini-Rucki, I hope I'm pronouncing that correctly, versus David Victor Rucki. And is it Rucki? It is. Thank you. Counsel, I understand that with respect to the respondents, Dakota County will be using 5 minutes for argument and the respondent Rucki 10 minutes. We'll be keeping track accordingly. When you reach the podium, please identify yourselves for us. Feel free to adjust the podium to the height you would like it. There's a button there someplace. And counsel for appellant may proceed. And please try to keep your eye on the light up there that will alert you with respect to the timing.
Thank you, Your Honors. I'm Michelle McDonald. I represent Sandra Grazzini-Rucki, who's the appellant in this manner. If I could get a couple of points across, it would be these. First of all, our child support system was not intended to allow wealthy parents to go after poor parents or for the county to facilitate such a action. Also, our system requires no showing that the children are not being supported with a home, the basic necessities of life, education, health care. What our system does basically is deprive children of the love and companionship of parents, which is, vital support for children. Also, the unnecessary complexity of our laws. For example, and I have the book here, 518 is comprised of 3 chapters, 518A, 518B, and 518C. And we're dealing today with child support laws that are 518A. And just quickly, there are 53 provisions. There are 81 pages in this book, single-spaced. And the columns, there's 2 columns. So these laws, and I just analyzed one of them. I'm going to get it for you here. When you look at 518A.26, okay, it has 23 subdivisions. The subdivisions have Subdivision 20 has 3 subdivisions, and Subdivision 21 has 5 subdivisions. So Subdivision 1 cites 518, Subdivision 2 cites the federal regulations, Title 38, 3.450 to 3.458, and so on. And that's just taking one of the chapters, one of the pages. And I just say this to help you understand that the first step in due process is clear laws. There's 6 steps to due process. The first one is clear laws. The last one is an appellate process, which I'm doing here. And we've failed in even the first step because our laws are not clear. Also, Your Honors, lastly, the courts abuse their discretion when they set support in a manner against all logic and facts on the records or misapply the law. And it's probably easy to misapply the law or at least make an argument that the law has been misapplied when the law is so complex, as in child support. And it should be pretty simple. I mean, the facts in this case were not disputed. First of all, this was a modification of child support. And I want to distinguish between those who refuse to pay and those who can't pay. Ms. Grazzini-Rucki, when she got her child support order, December of 2013, paid child support regularly from a regular job at the American Airlines for months and months and months and months, up until her October arrest. She was a payor. She paid it. And it was at her own expense because some of her paychecks had $40. Okay, and she is homeless, as she testified to, and she has no assets. So all of her paychecks, all of it went to support her children. Not to mention there were 5 of them. And let's talk about 5, try paying health care for 5 children. And at the time of the modification, the health care for the 5 children was $750, and it was going up to $1,400 a month. So she asked for a modification on that basis. She had asked earlier for a modification, and this is part of our argument because, and the record will reflect, she never, in the history of her being an airline stewardess, ever made, I think they said it was $4,143 a month. Never in the history. All the facts show it. She actually, that would be $49,716 a year. And Ms. Grazzini-Rucki provided all of her W-2s, and her W-2s actually show the most was 2012. That was the year of the custody order, and that was $30,098 in 2013. She provided all of her W-2s. She was clearly unemployed, not working, because she had been arrested, she had been in jail, she was facing criminal charges, she was going through a very public trial. And at the time of this evidentiary hearing on the motion for modification...
Could you attach a date to the hearing you're referencing, Ms. McDonald?
Of the evidentiary hearing? Well, let's see, there was a couple of them, but at the time of the evidentiary hearing, let's see, the order was October, so it was about a year following her arrest. So I think the evidentiary hearing was
October of 2016?
October of 2016 is when the orders came out. So I think it was just a couple of weeks before that, maybe
Okay.
Lisa will remember. So yeah, we have a year of undergoing criminal prosecution, which is very stressful. Obviously, you can't work. She's an airline stewardess. She had to turn in her passport. You can't be an airline stewardess without your passport. Very unrealistic expectations. And again,
you can fly domestically.
well, no, you can't. They want to make sure. I mean, think about it. I mean, these are just all assumptions, but she's the one who's been working there for 30 years. So to make a factual finding, well, you can fly domestically. No, she could not work. She wasn't even on the roster to work. So, and that's also, if she could work, she would work. You know, there were orders that she couldn't leave the state. I mean, she was facing criminal charges. I mean, she's trying to do the best she can under the circumstances. And she testified to all of that. But I'm just, you know, the problem really is that we have just a total lack of reality in what the court found here. One really big problem is not only did they impute income and they took an earlier order that was subject to the modification. That was the order she wanted to modify, was the order that held that she had $4,000, and I keep forgetting the figure, over $4,000 in income, which she didn't have. That was the order she wanted to modify. So to come full circle and say, well, she can make that, when that order already is deemed to be fallacious because of all of the information that she's given to the court of actual income, is somewhat nonsensical. I only have 6 minutes here, and so what we have here is we have the whole hearing was set up. First of all, it had already been deemed that this modification was going to happen, that she had met the standards for modification. So this was a modification hearing, and in a modification hearing, you have to look at the facts as they exist. And it was very clear that she had zero income. It was very clear that what the court was required to do based on an earlier order was to determine her ability to pay. There was no determination of her ability to pay. What the court did was actually not even look at the facts and say, what is her potential income? That could be something like maybe getting a low-paying job or a minimum wage. What the judge did was take the facts that were found in an order that she was modifying, and those facts were clearly erroneous because we were now seeing what Ms. Grazzini-Rucki actually was making all of those years. So that's why the facts were clearly erroneous. You have a question?
I'm just looking at the October 13th, 2016 order that is the one you're talking about.
Yes, yes.
And there were several factual findings made by the child support magistrate, and it seemed like the magistrate was attempting to deal with the American Airline income, but was lacking information. I mean, she makes particular factual findings such as her current employment status is unknown. Mm-hmm. No evidence her status has changed since March 11, 16. If in fact she is unemployed or duty to support her children mandate she provide any information necessary. And then later it says she's not rebutted the presumption she can work full-time. She doesn't claim that her employment with American Airlines has ended. Are you claiming that some of those specific factual findings are clearly erroneous? And if so, what would support that in the record?
Okay. Here, those are conclusory facts. Those are not facts. What a fact is in a child support proceeding is gross incomes. Now, since 2006, there is no, both parents are obligors. So the gross incomes of both parents, only since 2006, and I know that's 10 years ago, but it takes a while for all of us to catch up, has that been the case where that's the fact. The determination has to be what is the gross income. And in fact, the court in this order never determined that her gross income was zero or had been zero for several months. So they glossed over that fact, didn't even want to acknowledge that she had no income, and jumped right into the potential income phase, which isn't even, which first you have to say ability to pay phase. And the most egregious part of this order is not only that they just kind of ignored the facts with respect to the father. I mean, he was a millionaire. He testified to millions of dollars. And we had a very clear affidavit, unrefuted, that he owned a home, that over $400,000 that he lived in with the kids, and he testified it was paid for. Okay? He had another home that he was renting out. He had a trucking business for years that he just decided to sell or give away to his sister. Call it TL Trucking, and then it's operated out of his house. And these are facts that are ignored. So when we're determining his gross income, we could say myopically, well, look, he provided 1 or 2 paycheck stubs that say $5,000 a month from TL Rucki Trucking, his sister's business. His sister's a chiropractor, first of all. This is totally ignored. But we're not myopic with respect to the mother. She provides that she has zero income for several months. She provides all of her W-2s. She's not self-employed of what she made. We're not myopic. We just kind of pull things out of the air. So you can see how right away, she ends up with an order that's retroactive, and that's that non-protunct language. That's actually, there's something that I researched and I just found it called the Bradley Law, the federal law, where you cannot make a child support order retroactive. Okay, and that's what they did, but they did it the other way. Okay, she had, Ms. Grazzini-Rucki basically in this modification didn't have to pay support for 4 months. That's all.
Well, counsel, let me ask you this. If the court is considering a parent's voluntary unemployment, underemployment, or employment on less than a full-time basis under Section 518A.32, isn't the question for the court the parent's ability to be employed versus the parent's ability to pay?
It's the question for the court, the parent's ability to be employed. But that, we need to actually consider the fact that when somebody leaves jail, that their ability to be employed, or if somebody has 6 felonies, that their ability to be employed might be, as in this case, non-existent. And as we said in our brief, she was hanging on to her job. In fact, they're waiting for the appeal of the criminal matter. They're just she can't just go fly right now.
But that's why
That's unrealistic, and they even took her past job and said she has the ability to earn what she earned before and used a number that wasn't even on the record that she earned. And I just have a final, you do have a question, because I only have 37
Go ahead.
seconds. I was just going to say, the findings relating to her income were not part of the evidence, and she never made $4,143 a month or $49,716 a year. A conclusion that she had or could possibly attain the ability to pay $975 per month within the time set, which was retroactive 7 months, so she would have had to have the ability to pay off the bat $6,825. It defies any semblance of logic or human experience to suppose that on no income, with no assets, Ms. Grazzini-Rucki would be able to pay, not to mention retroactive to April, the order being October. The order is so far removed from reality as to suggest an actual disdain for reality. Thank you.
That's all right.
Thank you. You may proceed.
May it please the court, counsel, good morning. I'm Jim Donahauer. I'm an assistant Dakota County attorney. I represent Dakota County, which is one of the 2 respondents in this appeal. As the public authority responsible for child support, Dakota County intervened in this case, and at one time or another, the county has provided child support services to each of the individual parties. This case involves many issues, and the county has tried to respond to each of them comprehensively in its brief. However, with only 5 minutes of oral argument, I need to be very selective in the issues that I choose to present to the panel. Before doing so, though, I would like to make just a couple of quick comments about Ms. McDonald's opening remarks. She mentioned that the child support system is not intended to allow rich parents to, or should not be intended to allow rich parents to take advantage of poorer parents. She criticizes that there's no need to show need in order to obtain a child support obligation, and she complained of the complexity of the child support statutes. I would submit that none of those are issues that are properly present in this appeal. They are broader public policy concerns that are perhaps better addressed legislatively rather than in the context of this particular appeal. She mentioned specifically Chapter 518A.26 and gave that as an example of this complexity. 518A.26 is the definitional statute, and so I don't think it's surprising that a definitional statute would have a number of subdivisions, each representing one of the necessary definitions in a child support matter.
Well, counsel, I know your time is limited, but I would like you to address what the appellant's strongly stated challenge to the district court's finding that, and this is finding number 40, found at addendum 78, and this is in the October 13, 2016 order, and that is that mother earned grossly income of $4,143.12 in July 17, 2014. What evidence is in the record that supports that finding?
As it turns out, the one issue that I wanted to address this morning was the court's determination of mother's income. So I think we are almost literally on the same page in terms of what I'd like to address. As to that particular income, as has been noted, it was drawn from an earlier order. It was drawn from an order made in July of 2014. And in that order, the magistrate at that time focused primarily on a single pay stub, which showed biweekly income of, excuse me, just over $2,000. The court at that time characterized that as being substantially full-time employment, even though it only represented 41 hours over a 2-week period. From that single pay stub, the court extrapolated to a monthly income of the $41.43 that it used in that order. And I believe that's the origin of the number that Magistrate Pasteur used in her order of October 2013.
2016?
2016, correct. As I looked more deeply into this case, I found 2 other instances where appellant's income had been determined either by stipulation or by calculation by the court. One of those was in, I think, 2012, when Mr. Rucki's obligation to Ms. Grazzini-Rucki was in issue, and at that time, the parties stipulated that she had the ability to earn $5,000 a month.
Was that associated with the dissolution?
Yes. Subsequent to that, in the order that was issued in November of 2013, the court looked at Ms. Grazzini-Rucki's pay stubs over a 2.5-month period, and based on those, determined that her actual income at that time was, I think, $4,126 per month. So in the context of those other determinations, it is certainly arguable that the finding made by Magistrate Pasteur was not clearly erroneous, and I see that I'm out of time. Thank you.
Thank you.
May it please the court, counsel. I'm Lisa Elliott, and I represent the respondent David Rucki in this appeal. It seems that appellant's income has been the focus of the argument so far. I know that Ms. McDonald raised issues regarding my client's income as well, and I don't believe that the magistrate's orders at any point in their finding regarding my client's income were clearly erroneous. They based it upon his paycheck stubs, his tax returns, his monthly living expenses showed that he was living within those means. The appellant in this case wants the court to use income from a business that my client owned between 2001 and 2010, when he was in the trucking business and earning substantial, the company was earning a substantial income. That, however, the magistrate found was stale and irrelevant. Income from 2010, that issue was already addressed at the trial in 2013, found to be irrelevant and stale at that point, and it certainly was even more irrelevant and stale in 2016.
Will you address the issue of imputation of income to the appellant and the district court's basis for that?
The district court, the magistrates, absolutely. When the appellant filed her motion for modification in November of 2015, it was based solely on the fact that she was incarcerated at the time. Her income had been determined at least on 3 different occasions to be roughly $4,100 per month, based on a stipulation, based on the trial court's finding, and then based on a magistrate's finding in 2014. When she was incarcerated, the magistrate in January determined that, at least on a temporary basis while she was incarcerated, she had no income, and then set her child support obligation at 0. When she was not incarcerated, and we were back in a review hearing, for one of the several review hearings that we had before the magistrates, it was ultimately determined, I believe the hearing was in September 15th was when we had the evidentiary hearing. And at that time, the magistrate had to determine, since she was claiming she had no income and had only been applying for jobs at Taco Bell and Menards, et cetera, had to determine what her income potentially could be. The burden of proof is on appellant to prove what she could or she could not earn. The evidence up until that point was that she was still employed at American Airlines. She could still fly. There was no evidence before the court that she couldn't fly domestically. There's also evidence before the court that she could fly and get her passport back if only she provided the adequate information to her probation officer. She could get her passport back, she could fly internationally, she could go back to working the normal hours and jobs that she was working at American Airlines, earning the $4,100 per month. The fact that she chose not to does not mean that the court can't impute that income to her, because she's claiming, and she claimed that she didn't have that ability. And if the court would note, as Your Honor did, that what she's claiming is she doesn't have the ability to pay because she's indigent, she doesn't have any money, which is what her argument has been throughout this entire case. But that's not the standard. The standard is, does she have an ability to earn? And the court found, I think rightly so, that she has the ability. She's, as far as we know today, she's still employed for American Airlines. She could go back to work earning $4,100 per month, and she has an obligation to support the remaining 3 minor children. So the burden was on her. She didn't provide any evidence to the court that her circumstances had changed at that point. Once she was no longer incarcerated and she still had her job, I think the court properly found that an imputed income to her at what it was and has been for the last 20 years. I'm not sure I can address the additional issues that the appellant raised. I believe they've asking that the court erred by not making the child support, the zero child support retroactive to June of 2015 when she first filed her motion. However, that motion was filed in the district court and was dismissed by Judge Canning a month later. Then she did nothing for 3 months, and then in November 2015, she filed her motion to modify based upon her incarceration. That order should not be made retroactive for a couple of reasons. One, that there was no child support motion pending between the time she filed that motion and the time she filed her second motion, because it had been summarily denied. Second, the basis for her modification in November of 2015 was based solely on her incarceration, which was not a fact in June of 2015 when she filed her earlier modification motion. And finally, it's within the discretion of the child support magistrate or a district court whether or when to set a retroactive child support order, and there's no basis, there's no evidence before the court that the magistrate at that point erred in that regard. Second, her motion is that the court failed to make an adverse inference regarding my client's gross income. And again, that's based upon his failure to provide income information in his original reply and or responsive motion pleadings. The statute 518A.28 says that if a party does that, then the court has to look at the income information and evidence that's presented at the evidentiary hearing, which was held in September. And the court did that. The evidence that was presented regarding my client's income included his current tax returns and his current paycheck stubs. So to base, and I guess I was unclear into what adverse inference she was asking, unless she was asking that the court should then look to income that's 7 years old and determine what his income, that his income currently is what it was in 2010, even though there were 2 other court orders between that period of time that found his income to be exactly what the magistrate in this case found his income to be. The third issue that appellant has raised is that the temporary minimum amount of child support that the court ordered in August of 2016 was in error. And given that the October order made that order on child support retroactive to April, that interim order ordering $50 in minimum support really is null and void. It doesn't exist anymore because that October order goes all the way back to April, so that there's really nothing to argue about that issue at this point. Argument number 5 was that she argues again that the respondent's actual gross income was miscalculated. And part of her argument is based on the gross income tax return for a company that he had a 49% interest in, Kang Trucking, during the year 2014. In that year, my client was a 49% owner in a trucking company that ultimately failed. And appellant is asking the court to use the $1.2 million in gross receipts on that corporate tax return as his income for child support purposes. However, that isn't how you calculate or look at somebody's income if they're an owner in a corporation. You look at what their wages were, which were approximately, I believe, $40,000 is what his wages were from that corporation. And then you then look at whatever income he also derived from that corporation. And if you look at the tax returns, it shows that his income, he's a 49% owner. I believe the gross profits or the net profits from that tax return show there was approximately, I think, $40,000 or $30,000 in gross income or net income. My client had roughly 50% of that, so his income included his $40,000 in wages and then another $15,000 in income from the corporation, which shows $55,000 in income, which is right on point to what the magistrate found his income to be. So actually, that tax return supports the magistrate's finding regarding my client's income. Finally, her argument that the magistrate ruled prematurely before her sentence certainly doesn't apply in this case because the sentence, and everybody knew this at the time, the magistrate asked everybody what was the potential sentence that Ms. Grazzini-Rucki was looking at, and realized that it was going to be less than a few months in jail, and that it didn't make sense to wait and set child support when really what could be done is you could suspend her child support while she is serving her time, which is what the magistrate chose to do. And given that she's supposed to be serving 15 days every year for the next 6 years, the magistrate again determined that if during that period of time she's incarcerated, that her child support would be suspended. It certainly is nonsensical to have to come back to court every year if she's incarcerated for 15 days to have to redetermine what her child support obligation would be.
Do we have evidence of this sentence in our record, Ms. Elliott?
You know, I don't know if you do because the sentence, the appeal is from that child support order and it was before the sentence, which was about, I think, a few weeks after the child support order came out.
Okay.
So if the panel doesn't have any other questions?
I don't.
We do
Thank
not.
you. One thing I'm noticing is this trend, and this is, going on 30 years of practicing law, to not look at the evidence before it, but to make arguments that there was no evidence before the court that she couldn't get her job at the airlines, etc. So I'm asking, and I ask this court to look at the evidence, and don't be myopic with the one paycheck stub, the
Ms.
finding
McDonald,
that she had potential income.
Ms. McDonald,
Yeah.
that's why I was focusing earlier on the factual findings, because those are the findings made by the child support magistrate here, that there was insufficient evidence of these things. So,
Right. And
if there's evidence in the record that would make those findings clearly erroneous, I would appreciate if you would direct us to that.
well, the evidence is that there wasn't any evidence before the court. Do you see what I'm saying? That's what I'm trying to say. The evidence before the court was that Ms. Grazzini-Rucki had applied for multiple jobs. Then the court says, well, she didn't bring any documentation of that. The evidence before the court was that in 2000, and I have it here, in 2007, because the county doesn't get this information for self-employed individuals, but in 2007, David Rucki, the county had that he made $25,000 that year from Rucki Trucking, and his tax return that year was $4 million. Okay, so if we're going to try to look at gross income and we're just going to look at David Rucki's paycheck stub, then do that. But then when you're applying it to the person that has to pay, look at her W-2s. Don't look at some finding that looked at 4 paycheck stubs or 2 or whatever it was for an airline stewardess and said, well, in this block of time, this is how much she made. We had the W-2s. So, first of all, the finding's clearly erroneous, because the finding that's actual is that she had zero income for a number of months. That's the finding that's actual. And they didn't even start with that finding to determine what her potential income is. And they could have said her potential income isn't very great because she's just got convicted of 6 felonies. Her job is in flux. She doesn't know if she can go back there. So we need to be, if we were basing this more in reality, we would be saying, you know what, this isn't about pay support at all costs, because that's what it feels like. And there is a trend, and I've been reading about it, with there's obstacles to modification of excessive orders. Where people go in to modify, and then they say, well, you were making this much last year, so we're just going to impute income and move on. We need to start, if we're going to, how does this help the children to have a mother who, by all accounts, doesn't have her job at the airlines anymore, makes zero income, is ready to go be sentenced for felonies, and actually say she can pay support of $900 when she isn't even making that, and have it be retroactive several months to when you know she wasn't working. It's just, so that's what I mean by illogical facts and not based in reality. The courts have to start being connected to the reality of the situation when they're making their findings, and that's really hard.
But what is the evidence that she no longer has her job with American Airlines?
She testified that her job, she was unknown, okay?
Right,
and
but
the
that
court
doesn't mean
even
she doesn't have it. I mean, that's a different statement than...
Well, her job is unknown. To me, that was the reality of the situation for her at the time. It's still unknown to this day. Meaning that they're waiting for this appeal. They could fire her, but they're waiting for the appeal of the criminal charges. This is what she's understanding, and then maybe they'll give her her job back. She had been there for 30 years. So they're doing a lot more than anybody else would do, with 6 felonies. But that was it. And then if you're even going to say she, you could review it, and I've done this many, many times with courts. Let's review it after the sentencing hearing. Right now she's making 0. That's pretty clear. Let's review it after the sentencing hearing, or maybe when she gets her job back at the airlines. So there has to be remember, this was a modification, not a setting. So she was asking that it be modified because of her circumstances that had changed substantially. And I'm out of time. Thank you very much, Your Honors.
Thank you. The matter is taken under advisement.